Supreme Court opinions are typically written in formal, genteel language. Justices write circumspectly, almost never resorting to distasteful language, graphic description, or obscenities. It can be entertaining to watch a justice delicately describe the lurid images in a pornographic movie when deciding whether the movie is either obscene or constitutionally protected. And in Cohen v. California, it's interesting to see how the justices managed to avoid uttering the vulgar phrase that got Mr. Cohen into such trouble. Instead of telling us what happened in its own words, the Supreme Court quoted the operative facts from the decision of the California Court of Appeal. In 1968, Mr. Cohen was seen in the Los Angeles County Courthouse, quote, wearing a jacket bearing the words, "Fuck the draft," which were plainly visible, unquote. He was arrested, convicted of disturbing the peace, and sentenced to 30 days in prison. The California Court of Appeal upheld his conviction, and the California Supreme Court declined to hear the case. Cohen then appealed to the United States Supreme Court, which accepted the case to consider whether the conviction infringed on his First Amendment freedom of expression. Writing for the court, Justice John Harlan held that Cohen's conviction was unconstitutional. Cohen's conviction rested in large part on the fact that women and children could clearly see the message. In that day and age, the protection of women and children from such vulgarity was considered a valued social interest. But Harlan argued that protection of sensitive persons alone could not overcome Cohen's right to communicate his message, even by use of offensive language. Offended viewers could easily avert their eyes if they didn't want to see it. Harlan considered the recognized exceptions to constitutionally protected expression and concluded that the phrase on Cohen's jacket didn't fit any of them. It wasn't obscene because it didn't have any prurient or erotic component. It also didn't constitute fighting words because, while distasteful, it wasn't likely to provoke a violent reaction, nor was it an insult directed toward any particular person. The court expressly rejected the notion that the state of California could justify Cohen's conviction based on the state's duty to protect public morals. The court noted that Cohen didn't engage in any other offensive speech or conduct. Moreover, the fact that he displayed the phrase in a courthouse was also not germane, since California's Disturbing the Peace statute had no special provision for courthouses. The court argued that in a society as diverse and populous as the United States, the free exchange of ideas, even offensively expressed ideas, is a virtue worthy of First Amendment protection. Allowing the state to prohibit the public display of one offensive word would open the floodgates to the state restricting even more language, and inevitably to the state prohibiting the expression of certain ideas. This, the court said, was what the First Amendment was intended to prevent. So, without a more compelling reason to suppress Cohen's expression, the state could not prosecute Cohen for the public display of his message, even if that message contained an offensive word. Therefore, the court overturned Cohen's conviction. Justice Harry Blackmun dissented, joined by Justice Hugo Black and Chief Justice Warren Burger. First, Blackmun argued that Cohen's display constituted conduct, not speech. This brought it outside the First Amendment's protections, and thus within the state's right to regulate. Second, a later California Supreme Court decision cast doubt on whether the underlying California Court of Appeal decision still represented good law in California. Noting this, Blackmun would have remanded the case back to the California courts for reconsideration. Justice Byron White joined the second part of Blackmun's dissent. Since Cohen, the court has addressed other situations where people have used suggestive, vulgar, or offensive language to express themselves, notably in schools and at military funerals. For the most part, the court has continued to uphold First Amendment protections for those who choose to express themselves offensively.